Today I'm going to do a recording of the variable consequences of a civil marriage, specifically focusing on marriage out of community of property. Remember in my last recording, I stated that when prospective spouses enter into the marriage, their marriage is going to be automatically in community of property, unless if they're able to prove that there are circumstances that renders their marriage to be that renders their marriage not to be in community of property. One of those circumstances is when the parties enter into an antenuptial contract. An antenuptial contract is a written agreement where prospective spouses exclude all or some of the common law and statutory consequences of their marriage relating to the matrimonial property system. There are three types, or there are three options that prospective spouses can choose from. First one is out of community of property without the accrual system. This is also known as complete separation of assets of property. This means that when spouses enter into a marriage, they are not going to share anything, whether they're not going to share anything, whether be it assets or be it debt. And during the termination of the marriage, each spouse gets to keep whatever is theirs. The second option that prospective spouses have is out of community of property with the retention of community of property and loss. This means that in the antenuptial contract, the spouses need to specifically state that whatever we had or whatever we have before we enter into a marriage is going to be retained by the individual spouse, and whatever is going to be acquired during the existence of the marriage is going to be shared by the spouses in equal share, because it is a retention of community of property and loss, but excluding what they have or what they have acquired before they entered into a marriage. The last option that spouses have is out of community of property subject to the accrual system. Here, it means that when prospective spouses enter into a marriage in the antenuptial contract, they specifically need to state what is it that they want to form, what assets they want to form part of the marriage, and what assets they do not want to form part of the marriage. For example, let's say spouses have a pension funds. They can state in their antenuptial contract that they don't want pension funds to form part of their marriage. Or if there's an immovable property, they can state that whoever is an owner gets to retain that immovable property as their own asset. And while they are married, each spouse, they independently manage their own estate, and they are not accountable to each other, with the exception of the terms and conditions in the antenuptial contract. If, for example, the parties have agreed that no spouse is going to dispose of, let's say, of monies worth like monies from an amount of 100,000 and above without the consent of the other spouses, they are bound by that provision. So it means that while they are married, they have a right to independently manage their own estate. But it is important to note that the terms and conditions in the antenuptial contract actually play a role with regard to the extent that each spouse can independently manage their own estate. If there is no provision in the antenuptial contract preventing them from getting the consent from the other spouse, then spouses are free to independently manage their own estate. For an antenuptial contract to be valid and to be binding on that parties, for it to be binding on that parties, it must be entered into before a marriage. It must be in writing. It must be signed before a notary and two witnesses, and it must be registered at the deed office. When you study your prescribed textbook and study guide, please pay attention to CPI, the Consumer Protection Index. You need to understand what a commencement value is. A commencement value is the value of the assets or the estate that each individual spouse had at the time of entering into a marriage, because when the marriage terminates, whether through death or through divorce, the value at the time is known as an end value. So when spouses enter into a marriage, in the antenuptial contract, they need to record the value of the assets. So they record the assets that they have and the value of those assets. If, let's say, the spouses have more debts than the assets, the antenuptial contract, the commencement value is going to be recorded as nil. Calculating the accrual, it is important to know the date, the value of accrual. It is important to note that the value of accrual is determined at the date of dissolution of the marriage. Please note, please, it's important that you note and you become aware of the Supreme Court of Appeal judgment, which actually settled this dispute, because there were conflicting judgment regarding when the value of the accrual needs to be determined, and the Supreme Court of Appeal has confirmed that it is determined at the date of dissolution of the marriage. So this means, for example, if the spouses agree that we are going to separate, but they don't legally terminate their marriage, that separation is not legally recognized because it is not a dissolution in terms of the law. So when you determine the value of the accrual, it's going to be determined when the court says this marriage has now been dissolved. When calculating an accrual, the steps that needs to be followed is, firstly, you need to determine the net end value of each spouse. And net end value is what each individual spouse has at the time that the marriage has come to an end, whether through death or through divorce. Secondly, you need to determine the net commencement value of each estate, and you then subtract the commencement, subtract the commencement value from each end value to get once you subtract the commencement value, what the spouse had at the time of entering into a marriage, you subtract that from the net value, what the assets have at the time of ending of the marriage, taking into account assets which should not form part of the marriage. You are now going to be left with the end value, the end net value of the spouse's estate. The accrual of each spouse estate will then be determined. Thereafter, it must be determined what claim does the spouse whose estate is smaller has, or if they have no accrual. Here it means once it has been determined that this is the net value of each spouse. In other words, you have removed or you have subtracted the commencement value, you have subtracted what each all the assets which should not form part from the accrual calculation, which should not form part from the marriage. Once you've subtracted that, you're going to be left with each spouse's net value of their estate. Then once you have that, you are going to see from the value of the estate whose estate is higher. The spouse whose estate is lower gets to retain their estate, and they're going to have a share, a half difference, a share which is equals to half difference between the two estates from the spouse whose estate is higher. So this basically means that the spouse whose estate has not accrued any value or which value is lower gets to retain everything that is theirs, and they have a claim over the other spouse whose estate is higher. Important information when calculating accrual: subtract all the assets which are excluded from the accrual in terms of Section 4 and 5 of the Matrimonial Property Act before determining the end value of each accrual. If the antenuptial contract is not properly executed and registered at the deed office, it is not binding on third parties. It is only binding on the individual spouses themselves. Accrual is the amount by which the net value of the spouse's estate at the dissolution of the marriage exceeds the net value of the estate at the commencement of the marriage. Accrual, it's important to know that accrual creates a contingent right. Accrual system does not give the spouse the right in each other's asset. So this means that while the spouses are married, the spouse have a contingent right. In other words, a right towards the estate or the asset of the other spouse, but those rights cannot be accessed or exercised while the marriage is still existing. They can only be exercised when the marriage has been dissolved or during the process of dissolving of the marriage. So accrual system does not give the spouse the rights in each other's assets, but it gives them that a contingent right which is going to be exercised only when the marriage or upon termination of the marriage. It is also important to know that the net commencement value must be adapted according to the average of the consumer price index, the CPI. The net commencement value of an estate must be expressed in terms of the value of money at the dissolution of the marriage. Students, it is important that you read your prescribed textbook and the study guide to actually read in detail, but this was just a summary. You are free and you are welcomed to send me an email if you want to talk to me, or if you do not understand anything, or if you need clarity on something. My name is Ntabisa Munaring and my email address is monar@unisa.ac.za. All the best with your exams, all the best with your studies, and remember, feel free to send me an email if you want to talk to me privately. Thank you. This was just a summary of the variable consequences of a civil marriage for out of community of property. The next recording will be on altering the matrimonial property system. Thank you, student, and all the best with your studies.